I am Veronica Jacobs. I worked for Houston Volunteer Lawyers for 27 years, and I was at the meeting in the year 2000 when we first began the Will-A-Thon. The Will-A-Thon has grown a great deal since then. I think our first Will-A-Thon, we had 35 clients, and we've, in the past couple of years, in the year 2000, we topped out at over 200 clients. You won't have nearly that many this time, just you and your client, and that's all you have to deal with. What I'd like to do is share some of the information about the Will-A-Thon and things to expect from clients, just so you'll know how to handle situations and you won't be left in the dark. HVL will certainly be sharing my email address, and I'll be happy to serve as a mentor to any of you who have questions, either today or while you're going through the process of the Will-A-Thon. The first challenge you may have is client confidentiality. Often family members, caregivers, or the niece or nephew of the month think they need to be present when you're interviewing your client. Even if you're interviewing your client by phone, please explain to them that because of attorney-client privilege, you need to interview them, and they shouldn't have someone else prompting them with the answers they want the client to give. They are free to share the information with their loved ones later on, but for their sake and for yours, please try to keep the conversation between you and the client only. Oh, you'll get the pushback that's saying, well, I'm always with Aunt Martha, I always help her answer questions, etc. At that point, if you think your client does not have capacity, you may explain to the individuals that the client needs to be able to provide the answers on their own, or you won't be able to proceed. And usually after that little speech or that little statement, Aunt Martha is a lot more capable. But I just want to let you know that may be a problem. I'll go over each of the documents that we generally execute at the Will-A-Thon. There are approximately 10 of them. I'll just list them and then I'll go talk about each one of them. First, there's the will. Then there's the transfer on death deed, the statutory power of attorney, the medical power of attorney, the HIPAA release, the declaration of guardian in the event of incompetence, the directive to physicians, and the appointment of agent to control disposition of remains. You may want to create a checklist of the documents just to make sure you haven't left any out, but after a while, you'll get used to doing these documents. First of all, as I mentioned earlier, your client needs to be competent. A way to kind of feel that out is to engage your client in conversation, maybe in terms of where they were born, what kind of work they are doing or have done before they retired. You want to ask them about the names of family members, their date of birth, marriages, etc. This gives you a chance to become a little more comfortable with the client and the client to become a little bit more comfortable with you, but at the same time, you'll be able to ferret out whether your client is competent. And go ahead and proceed. If you don't feel the client is competent, touch bases with another attorney in your office or someone else who can come in and help you maybe make that determination. But as I said, the client must be competent to have a will done for them. The will must contain a complete description of the client's family. Now, this can be a touchy situation sometimes. Some clients have children they want to forget about, or they may have children that their current family doesn't know about. That's another reason confidentiality can be important. Let the client know that all of their children need to be named in the will. They don't have to know where they're living or where they are or whether they're, or ever going to see them again, but they don't want to ignore the existence of a child, because that can be grounds for contesting the will. Also let them know that they are not required under Texas law to leave their children missing or present, anything at all. They just need to name them in the document. Remind them that whoever they leave their property to is up to them, and nobody's entitled to the things they have worked for all their life. The description of the family might include something like, I have a child who I haven't seen in 3 or 4 years. I am married, but I haven't seen my husband, whatever his name is, in X number of years. But you just want to make sure that the description is complete. The client can disinherit anyone he or she chooses to, but it's not necessary to leave a reason for disinheriting someone. I had one client who told me, I just want to leave my daughter one shoe. And I said, Miss Jones, you just want to leave her one shoe? And she said, yes. And I'll put it in that will, put it in that will. I am leaving her one shoe because I took care of her all her life, and it's time for her to stand on her own 2 feet. Well, unfortunately, Miss Jones passed away, and I had the honor of telling her daughter that her mother was leaving her one shoe, but she didn't even have to leave her that. Situations or stipulations to beneficiaries may not be able to be enforced by law. Some clients want to say things like, I want to leave my house to my daughter, but I don't want her husband to live there. They can't do that. I've had one client say to me, I'm leaving my house to my children, but I don't want anybody who doesn't live there to be there after sundown. That's something that can't be enforceable by law. Often clients will want to leave their property to their grandchildren. They want to make sure that their grandchildren will have somewhere to stay. Well, under Texas law, children under the age of majority cannot inherit. And there are some real problems with those situations. A 7 or 8-year-old can't maintain a home. They can't pay taxes. They can't pay the mortgage if there is one. So it's not advisable for clients to leave property, particularly real property, to a younger individual. In the event that it's personal property, they can always appoint a trustee to take care of the property. In the event, maybe it's grandmother's necklace or something, they can always appoint a trustee to take care of the property for the child until he or she is of age. Another thing clients often do is leave their home to all of their children. That's a noble thing to do, but it's difficult to deal with oftentimes in reality. But if that's what the client wants to do, you just go ahead and let them do so. Now you come to the problem of appointing an executor. It's generally not a problem if the client knows which of her children or friends or relatives will take on the role of the executor, will be able to go to court if the will needs to be probated, will be able to divide the property and make sure it gets to the person that the client wants it to go to. Some of the things the client needs to think about in appointing an executor is to make sure they don't have a criminal background, because the probate courts have a long memory when it comes to someone who has a criminal history, and will generally not appoint that person as executor. The executor also needs to be in the state of Texas, because the person needs to be under jurisdiction of the Texas courts in order to serve as executor. Some clients want to appoint their children to serve as co-executors. Now, this sounds really great, but if the children don't get along while the client is living, they're not going to do any better after the client has passed away. I would just urge them to appoint one person as executor and then appoint some alternates. It's always good to have alternates anyway, but appointing co-executors can be a problem. But if the client insists, it's not up to you to try to resolve all those issues, but it's really better to have one person as executor. One thing you want to really be aware of when you're, after you've drafted the will and you're ready to execute the will, is the will ceremony. You will receive a will ceremony script. It's important to go by that script because oftentimes the way the will ceremony is conducted is used as a means to attack the will. You want to make sure you have 2 witnesses and a notary. The witnesses cannot be persons that are related to the client or who will be beneficiaries of any part of the client's estate. You should not serve as your own witness. Get someone in your office or someone from the HBL staff to serve as a witness for you. The other thing is that neighbor, that caretaker, or that niece or nephew of the month should not be sitting at the table when you do the will ceremony. That could lead to a person saying the person was under duress and they just said that because Jolene was sitting at the table and he or she, your client, didn't want to upset them. So ask the persons who are not a part of the will ceremony not to be at the table. You also want to impress upon the witnesses and perhaps the notary and the client that the will ceremony is important. The cell phones should be off. People should not be texting and should not be holding sidebar conversations during the will ceremony. There is a video available of the will ceremony and how it should be conducted that you can look at before the ceremony. So just review it, review the will ceremony script, and it won't be a problem. A fairly new document that you'll be doing is the transfer on death deed. We commonly refer to it as a TOD. This transfer on death deed will only be important if your client owns real property in the state of Texas. Some clients own property outside of the state of Texas. This transfer on death deed does not apply to property outside of the state of Texas. And if the client does have property outside of the state of Texas, they will need to take care of that property in the state where it's located. The purpose of the transfer on death deed is to have the client determine who he or she wants to leave her property to, put that information in the transfer on death deed, and have a legal description of the property in the transfer on death deed or the TOD. That legal description is not the description that's on the HCAD or Harris County Appraisal District site. You will need to see the deed of the property or have the client provide you with the legal description of the property. It's important for clients to know that just because they do a transfer on death deed, now they're not giving up the rights to their property. They can transfer the property, sell it, or do whatever they want with the property while the transfer on death deed is on file. The transfer on death deed does not become effective until the client's death. The client can revoke the transfer on death deed if he or she chooses, either by executing a revocation and filing it in the clerk's office, or by doing another transfer on death deed. It is very important for the client to know that the transfer on death deed must be filed in the county where the property is located before the client's death. Again, you may need to remind them that day and maybe a couple of weeks later to find out if they filed the transfer on death deed. It's really important because without it being filed in the county where the property is located, it will not be effective. It's been my experience that sometimes clients don't file the transfer on death deed. So what I do is I put the bequest of real property in the will as well as on the transfer on death deed. So in the event they don't ever file it, the information will be in the will and the property can be transferred that way. But the transfer on death deed just makes it a lot easier. But for some reason, our clients, like some of us, don't like to go down to the courthouse too often. So you just want to have it in the will as a backup. Another document that clients are more familiar with, but they may not realize how powerful is the statutory durable power of attorney. They refer to it just as a power of attorney. You may ask the client, or you should ask the client when you begin, if they have any powers of attorney out there. Sometimes clients do powers of attorney and they forget about them. But the powers of attorney don't just disappear after a matter of time, they don't expire. If the client has a power of attorney out there and they no longer want that person to serve as their agent, please do a revocation of that power of attorney, and you will be able to get information from Houston volunteer lawyers about the form to do a revocation. The power of attorney is a very, very powerful document. No witnesses are required, but the agent or the person that the client appoints as their agent literally stands in the shoes of the client and can do with the client's property what he or she wants. But the good thing about this document is the power of attorney can be effective immediately, meaning when the client signs it, or the client may say, I don't want it to be effective until I'm incapacitated. Again, because this client is really turning over a lot of power to someone, he or she should be very careful as to who this person is, make sure that the person is very reliable and trustworthy. And also they just need to know that it's good to have an alternate in the event their agent is not available. In addition to the statutory durable power of attorney, clients will need to do a medical power of attorney. Again, the medical power of attorney, like the statutory durable power of attorney, involves appointing an agent. The difference is the medical power of attorney appoints, the client will appoint someone who will help him or her make medical decisions. Let the client know that they're not turning over all the decision-making to their agent. They may already be relying on this person to help them with medical decisions, but it's good to have this document in writing, because every time they go to the clinic or doctor's appointment or need to be hospitalized for any reason, they will be asked if they have a medical power of attorney. And if not, the doctors or the people at the nurse's station will ask them to fill out the information right then. Now, if you're in a lot of pain and you want to see a doctor, it is really difficult to remember names and phone numbers and who you want to appoint as your agent. So it's good for the clients to have this document done ahead of time. And it's also good for the clients to have the medical power of attorney in their doctor's office, filed with the doctor in their chart, so they won't have to go through this every time they go to the doctor's office. It's also good for the client to have extra copies of the medical power of attorney in their hands, in the hands of their agents. So in the event they have to go to the hospital or there's some type of emergency, the documents will already be in place. The medical power of attorney works in conjunction with the HIPAA release and the directive to physicians, which I will discuss a little bit later. When you do the medical power of attorney, please date it, have the client sign it, and put the time the document is signed. The reason we put the time that the document is signed is because when you do the medical power of attorney and directive to the physician on the same day, there could be some confusion as to which document was done first. I always do or execute the medical power of attorney first, because the directive to physician will be the client's decisions regarding whether or not they want to be put on life support. And you want to make sure the client's wishes are upheld. Again, the agents in the medical power of attorney do not take over the client's decision-making, and they can't overrule the client's decision-making as long as the client is able to make the decisions for themselves. And the clients really should discuss what they would like to do in terms of their health care with their agent. For a long time, I worked with persons living with HIV and AIDS, and my clients will say, well, I don't want my mom, my dad, or whoever to know that I'm HIV positive. And I would just simply have to have the conversation, is that your agent cannot be effective if they don't know about your health situation and they don't know what your wishes are. So let the client know they need to discuss their health care and their wishes with the agent prior to appointing them or shortly thereafter. The other document I briefly mentioned was the HIPAA release. In plain old English, it's a confidentiality release, which doctors' offices, clinics, nursing homes, and sometimes even pharmacists will ask for a HIPAA release. In this document, the client will list the person or persons that the clients would like to have information about their health care. In this document, don't just list the agent's name and address. Please list the agent's phone numbers, their cell phone numbers, because often if it's an urgent situation, the medical staff will need to get in touch with the agents fairly quickly, and the client may not be able to assist them in providing phone numbers. So just put the list of persons that the clients would like to share this information with. Now, those agents will generally be the same agents that are on the medical power of attorney, but they may have other people listed as well. They may have people like other brothers and sisters or nieces and nephews who they don't necessarily want to have to make decisions regarding their health care, but they want them just to know what's going on. So there may be additional people on the HIPAA release. And the HIPAA release is generally a 1 or 2 page document. No witnesses are required, but it's a very important document. So the client, the medical staff, and others will know who the client wants to share their health information with. One document that we hope the client will never need, and which is the reason we do all these documents together, is the declaration of guardian in the event of later incapacity or later incompetence. In this document, the client can appoint the agent or agents who they want to be the guardian of their estate as well as their person. These people don't have to be the same person. Different people have different talents or skills. So they may appoint one child or one person to be the agent for the declaration of their estate and a different person for their health. It's really important that they disqualify the persons that they don't want to hold this position. This is really important if they have a spouse out there, they just hadn't gotten around to divorcing yet, or they have a daughter or a son from whom they've been estranged, and they don't want them to come in and make those decisions, because by law, they're married until the judge signs a decree that says they're not. And in the event this document is not done, they have an estranged spouse and he or she shows up, he or she has the right to make decisions regarding their health care. Also, if they're not married and an estranged son or daughter shows up, he or she may be the one making decisions regarding their healthcare, in terms of whether they need to be put in a nursing home or other decisions such as that. So let them know it's important to appoint who you want and to disqualify who you don't want. They don't have to give a reason for disqualifying a person. These documents, the will, the medical power of attorney, the declaration of guardian, none of these documents are meant to leave blessings or otherwise to persons who have been a part of your life. Also, the client needs to know if at some point they've appointed a spouse as the agent and then later divorces that spouse, the spouse's serving as their agent will become null and void by operation of law. So maybe your client has had documents done a long time ago or a declaration of guardian done a long time ago and have appointed a spouse and they're no longer married to them. They won't serve as their agent. But it's always a good idea to keep the documents updated and just execute another one. It's only a 2 or 3 page document. It doesn't take a lot to do another document. So it's better for the clients to think about what, if they have any documents laying around the house or anywhere, so they can keep the documents updated. Our lives change, the people in our lives change, and we want to make sure that the information we have in these documents is current. The directive to physicians. Clients know this as a living will. Everybody calls it a living will, except us in the legal world. Be sure your clients know that the living will and the last will and testament are 2 separate documents. At the beginning of the conversation with your client, they may start to talk to you about the living will from the very beginning, and let them know that they will do a will to leave their property to the persons to whom they wish. And the living will is a separate document where they can say whether or not they want to be put on life support, should that become an issue. Let them know that they have options on the living will. Just because you or the client does a living will does not mean you have to sign a document saying, I want them to pull the plug and not let me be on life support if I get very ill. There are 3 options on the living will. No matter what my client tells me, no matter how sure they are when I talk to them, I always include all 3 options on the document. Instead of having the client check the option they choose, I have them initial it and then scratch through, or as I say, squiggle through the options you do not want. I want the clients to know that they have an option. They can change their minds later on if they decide to revoke this document. And other times you will find clients who are not comfortable with signing this document. They may start to ask you medical questions about what has to happen before they decide whether or not I have to be put on life support. I always fall back and say, if you're not comfortable signing the document, let me give you this document that hasn't been signed, hasn't been initialed by you. Take it to your healthcare provider and speak with them about it. And then you can come back later and decide what you want to do. Don't push the issue, because for us, doing wills and documents can be fairly routine, but it's not routine for many of the clients. For many clients, you may be the first attorney they've ever had to represent them, and they may be looking for you for guidance that is beyond the scope of your representation. But as I said, make sure that the client knows that he or she makes their own decisions, and if they change their mind later on, they can revoke the document, either by tearing it up or by signing another document that shows that their desires have changed. it's always better to have another document than to physically tear it up. The last document we're going to discuss is the agent or the appointment of the agent to control disposition of remains. Funerals can be very important to clients and goodness to their families. The client should appoint the agent or agents that he or she wants to take charge of their funeral arrangements. The client can help a lot by giving you as much information as possible about what they want for their funeral arrangements. Some clients don't want a funeral at all, and they can make this known in the agent to control disposition of remains. This is a document that should be given to the to the funeral home that is going to handle the funeral. The agent should sign off on this document accepting the appointment. The document can be as specific as saying which funeral home they want, what hymns they want sung at the funeral, what they want to wear, as specific as they want. I mean, some clients have even said which minister they wanted to give the sermon, but I have to tell them, you may outlive the minister, so let's kind of leave that a little bit flexible. Some clients may not want a funeral, they may not want the casket open at the funeral, but it's very important, a very important document. They need to discuss this with the agent or agents, because family members may have different ideas about what the client's funeral should be like. It's a very emotional time for a lot of the family members that are involved. So if the client leaves as much direction as possible, that will help a lot. The agent also needs to know where the insurance policy is, because the funeral home will want the insurance policy as soon as the person's remains are brought to the funeral home. The other thing is the agent will be the one that's responsible for gathering the funds to make sure all the funeral arrangements are paid for. Again, these documents, all the documents together, serve a really important function for our clients and their families. It's empowering. The documents are empowering for the clients, and it's really a gift to their families. And without you as attorneys, the people in your office who assist you, there is no way Houston Volunteer Lawyers, the Elder Law Committee, or any of us could get this work done. I'd like you to know that I will be available. As I said, I'll leave my email address with Houston Volunteer Lawyers. I'll be available to answer your questions and to guide you along the way. It's not difficult to do, but like anything, when you do it the first time, you have questions, feel free to email me and ask me, and I'll be happy to look at your documents to answer any questions you have. There are no stupid questions. Your clients will ask you questions that I have never been asked, so don't worry. We'll find the answer. If I don't know, I'll go to someone else and we'll find the answer and we'll do it together. We're all in this together. What I would like for you to do, to make sure you do, when you finish the documents, you finish executing the documents, make sure the client has the original, but you have a copy that you've made available to HVL. HVL needs a copy of the executed documents. So many times clients move, they lose the documents, and they will call, or their family members will call if the client has passed away, to ask for a copy of the documents. If HVL has a copy of the documents, those documents will be scanned into our computer, and it makes it so much easier for the clients to access, the clients or their loved ones to access those documents in the event they are misplaced. I mean, it's a very gratifying thing to be available to help clients and or their loved ones during the period of grief, because it can lead to a very extreme period of grief. Please make sure you leave a copy of those documents with the HVL staff, and the client has the original. Ask the client to put the original in a really safe place and let somebody, possibly the executor, know where the original of the document is. It's much easier to probate an original of a will if you have to go to probate than to prove up to the court that the original has not been lost, stolen, or destroyed. So it's good to have the original. Always have the client and the witnesses sign in blue ink, so that way it's easier to see which is the original rather than which is a copy. Some other rules of the road: I always put or have the document drafted in at least 12 font type. Our clients really need to be able to read the document or have someone read the document to them, and it's much easier if it's in large font type. I put the name of the client, all the beneficiaries, and the agents in all caps. Yes, it's easier for the client, but it's also easier for me and for you to see if a name has been misspelled. And that's important. We want to make sure all the names are spelled correctly, because some people really have exotic spelling of names. And I really can't determine, or you may not be able to determine, how a name is spelled just from the pronunciation. But most of all, I'd like to thank you for agreeing to represent clients with their estate planning. I'll be glad to answer any questions, but make sure the client knows that your representation has ended at the end of your case. And if you fill out that final disposition form and return it to HVL, HVL will know also when the client calls and asks for you, because they'll never forget you. They'll always remember your name. But HVL staff can let them know that that representation is ended, and they will need to open a new case if they need further representation. Again, thank you for assisting us.